This
Nancy?
conference will now be recorded.
Great.
Here. Hi. Welcome, everybody.
Kent Barnett,
Hello, thank you.
Jack M. Bierman,
Jack is sort of here. He was just on. I don't.
He's
oh,
coming.
right. Yes.
Yeah,
of
he's the
course.
one who went to class, right?
I was like, I know I saw that name. Okay. Michael J. Cole.
Yeah.
Anika S. Cooper.
I'm here.
Great. David Engstrom.
I'm here.
Claire J. Evans.
Yes, I'm here.
Shiv Feldblum. Renee Landers.
I'm here.
Robert Lesnick.
Here.
The Honorable Alexander Manuel.
Yes, I'm here.
Great. Thomas McCarthy.
I'm here.
Judge Penny Lucas. Okay. Patrick R. Nagel. Roxanne L. Rothschild.
I'm here.
Chief Judge Eleni Rumel. Christopher J. Walker. Judge David L. Welch. Dr. Russell R. Wheeler. William Funk. I'm sorry, I'm not sure if your audio is working. So I see that you're unmuted, but I still can't hear you. So we'll have to work on that technical issue. And then Joseph Salome.
I'm here.
Okay. All right, Nadine, or rather Matt, would you like to start us off with some opening remarks?
Very, very briefly, I'd like to turn this back over to Nadine. What I'd like to do is thank everyone for joining us today. This is a very, very good group. I can see that just scanning my screen here. I can't imagine a better group to address this particular recommendation. And I'd also like to welcome Kent and Russell back for another round on this issue. And we very much appreciate the report that they prepared in 2017. And that will certainly play an important role, I hope, in the committee's deliberations. With that, let me turn it over to Nadine with my profound thanks for giving so much of your time to us this fall, Nadine. Maybe we can give you the spring off.
That sounds great. I'm going to hold you to that, Matt. So welcome, everybody. It's good to see some familiar faces. I would ask if you're willing and able to use your webcam. It would be great to see faces. So if you please do that, that would be wonderful. Just a few words about what we're going to take up today. Obviously, many of you are familiar with the work that the project that Kent and Russell led on administrative judges, and obviously many of you know that recommendation that was produced from that report was not ultimately adopted by the conference, but aspects of this work were well received and led to some spin-off recommendations that I believe we adopted last year, which seems like ages ago. One of them was recusal rules, another one was recruitment and selection of ALJs. There's been some great product that's come out of this work, and so I'm happy to have Kent and Russell both here today. So this particular project that we're taking up today, I'm viewing it as other ACUS disclosure projects have been, focused on the public-facing aspect of agency adjudication. So you know, the idea that a member of the public enters our sphere, right? They come to the process, either it's an enforcement proceeding or it's an entitlement proceeding. And how much do they know about the process is one thing, but how much they know about the people tasked with making the decisions that will impact them is another. So I think this is an important project. I think it will be hopefully one we'll discuss openly and freely today. I did want to mention one point that I think it's important to keep in mind before we really get started, is that this is focused, this recommendation and project is focused on disclosure and not substance. So we're not talking about what agency policies or practices should be. It's more the way, the best way that information can be presented for use by the public and maybe other agencies to learn from. So there's 4 sources of information that we have that we can talk about. We have Kent's report, we have 2 law review articles that kind of came out of that report, and then we have Leanne's report, which is built on that. So there's a lot of information here, Rich, for discussion. And so before I turn it over, I believe it's Kent first. Leanne will tell me if I'm wrong. I have several housekeeping matters that we need to cover since we have this new virtual way of meeting. And I have to say I'm in my office today, but ACUS's offices are 2 floors down. I really wish we were all down there gathered and things were as they used to be. At any rate, housekeeping matters. 1, ACUS members have full speaking privileges, and you are able to unmute yourself to speak. To avoid background noise, though, please keep your microphone on mute, and you can raise your hand if you want to speak, or you can add a comment in the chat feature. Hopefully many of you, most of you know how to use that if you want to speak. I will call on you, and then you can unmute yourself and then remute yourself when you're done speaking. Webcam we talked about. If you're willing and able to do that, I would love to see faces. I think that helps this process. Haven't done several of these over these past few months. Seeing people is helpful. If you are a member of the public, please use the chat feature to indicate if you'd like to speak, and I will turn to you at an appropriate point in the meeting. Please keep in mind that members of the committee, which includes government members and their alternates, public members, senior fellows, liaison representatives, and special counsel have a vote, and they will speak ahead of anybody who is participating as a member of the public. Let's see. Yeah, use on the chat function. So I've seen this before in some other meetings I've been involved with. Please use it only to indicate if you want to speak or to vote when we get to that point. I really would discourage and ask you not to engage in sidebar discussions or substantive comments in the chat feature. I just think that we can have these discussions virtually with all of us on board. So please do that. I think that covers everything. Leanne, tell me if I missed anything. I will turn it over to Kent. You will be in good hands. Thank you.
Thanks, Nadine. It's good to see so many familiar faces, and I know many of you have some recollection of the earlier report that Russell Wheeler and I and some folks from the Institute of the Advancement of the American Legal System put together back in 2018 called the Non-ALJ Adjudicators in Federal Agencies, Status, Selection, Oversight, and Removal. And as you can tell by that, what we were concentrating primarily on were things that were related to the non-ALJ's independence or impartiality, and also seeking to get a better feel for exactly what their place in the current federal administrative state is. And we were building on 2 more limited reports that had occurred previously. One from 1992 that ACUS had commissioned, and it was focused, although quite broadly, it was focused more on the kinds of hearings that were being heard by non-ALJs and the caseloads. And then there was a follow-up report done by the Office of Administrative Law Judges in the Office of Personnel Management back around 2002. And it was much smaller in nature, but it was also focused primarily on the number of non-ALJs and their caseloads. And what we did was try to update much of what they had done, but focusing less on the caseloads and more on the independence. And I'll give you just a very brief summary of it. I do mean very brief, just enough to tee up Leanne's report of this and understand what I think is most prevalent to what she'll be speaking about today. When we engaged in our project, we used a survey model that sent our survey out to primarily our ACUS contacts at 64 agencies. And there were 30 agencies that responded indicating that they had the kind of non-ALJ hearings that we had used as part of our definition. And within that, we heard from those agencies that they had 47 types of non-ALJ hearings, so different kinds of statutory or regulatory hearing programs. Within that, they had 37 types of non-ALJs, meaning that there could be many of a certain class of non-ALJs, but within all of the agencies, they would identify 37 different types of these non-ALJs. And they were hearing subject matter in numerous categories, including for enforcement, benefits, contract matters, and a number of miscellaneous subject matters as well. We asked them, as we indicated earlier, primarily about the kinds of provisions that speak to their impartiality, and also those kinds of things would just give us more of a sense of what they look like in the current administrative state. And as for part of that, we wanted to know just what kind of titles do they go by? And we learned they went by 23 different titles, some with judge in the name, some with something akin of hearing officer, something like that. And we also tried to figure out what their number was. And if you used a more conservative measure that was used in an earlier ACUS report that Michael Asimov used, you would get something in the neighborhood of 2,000 non-ALJs, which would be roughly commensurate to the roughly 2,000 administrative law judges. If you used the more capacious definition that we did, which included anybody that could oversee a hearing that a party could request from a federal agency, the number went to more than 10,000, and most of those were patent officials within PTO, which had been hiring significantly over 2,000. And then when we turned to the specific provisions that dealt with their impartiality, we looked at things like whether they had separation of functions. And for instance, we found out that about 43% of the types, those 37 types we talked about, had no separation of functions. We also looked at ex parte communications. We found, for instance, that about 14% had no limitations on their ex parte functions. Most had something that required their recusal. And most, about 76%, had performance appraisals by those within the agency that they worked for. They were also eligible more than 70% of the time for bonuses within the agency. And although it's fairly difficult to find information on bonuses, they did report to us that the bonuses could be from a few $100s to all the way up to $36,000. And then finally, for one of the key criteria that we had asked about were whether or not they had at-will removal or some kind of protection. And only 3 of the 37 types reported some kind of protection from at-will and removal above and beyond what one would have under the normal civil service. And the key distinction in that is that for the civil service, the agency itself decides whether whether it would be more efficient to allow this removal or some other cause exists, and there is merely review by the Merit Systems Protection Board, another independent agency. For administrative law judges and a select number of non-ALJs, there is good cause whereby the agency doesn't make the initial determination. Instead, it is the Merit Systems Protection Board that makes the initial determination of whether cause exists for that removal. The other key thing as it relates to Leanne's presentation today goes to not only what the types of things we were looking for were, but how the agencies presented those. And we found that the provisions that related to this independence were found in numerous formats. It could be in statute, it could be in a substantive regulation, it could be in a procedural regulation, it could be in other various internal documents or guidance. And somewhat to our surprise, significant amounts were just found in custom, where it was reported to us it was just the way things were within the agency. In light of all of this disparity that we saw within which provisions applied to which of these judges, and also the disparity of formats and finding out where one would learn the information that goes into the provisions that influence impartiality. In a later law review article that I did building on this work, it's called Some Kind of Hearing Officer. And what its point was is that it's very hard to figure out what non-ALJs look like. And we see this in the disparate number of titles, the different kinds of provisions that apply, the different kinds of hearings which they adjudicate. And I proposed a disclosure regime where there would be a one-page disclosure that would address 8 different factors related to impartiality, and it would make it clear what the agency's handling of that particular provision was, and it would also have a place for the agency to say where one could find that information. And the idea was to simply make it easier for those who are affected by the agency's decisions to have more confidence and knowledge of the adjudicators who are presiding over the hearings. Second, to provide more information for Congress, other agencies, and researchers to know what's going on in this sometimes referred to as hidden judiciary within the federal administrative state. And then something that I think may even be more important than that, simply by having a disclosure, giving the agencies themselves and their adjudicators an ability to contrast and compare with other non-ALJ programs to figure out whether or not they really had achieved the kind of independence or impartiality that they were seeking. And it would allow them to have this very thoughtful moment to consider what kind of provisions they would like to have in place, and perhaps taking some of these things that were perhaps in custom or in guidance documents that were not widely available to be codified in a way that was easier for others to find the information and have more confidence in the adjudicatory system. So again, with that brief summary of it, I'll just hand it over to Leanne, and I think you'll see hers really just builds on in a very nice way on this earlier work that we've engaged in.
Thanks, Kent. So as Nadine and Kent have just talked about, this project grew out of prior work for ACUS, but since Kent's work, there have been some other developments in the area, including some litigation and President Trump's executive order on the hiring of administrative law judges. So ACUS thought it was time to begin a project on the subject of disclosures about agency adjudicators to help answer some of the questions that have come out of those developments, with the goal of creating recommendations about what information to disclose, where to disclose it, and how to disclose it for agencies with adjudicators. The project aims to highlight best practices for disclosing information because disclosures about adjudicators are important for both the public and agencies. A greater transparency for the public helps encourage faith in agency adjudications. And it may also be helpful for agencies because it may be cost effective if they're dealing with a lot of FOIA requests on this area. And it may be helpful for comparing practices and learning from each other's experiences. It's also helpful for the public to help understand agency adjudicators' impartiality and their constitutional appointment status. So for this project, we selected 16 adjudicators, and I conducted a number of searches throughout some sources, specifically the United States Code, the Code of Federal Regulations, the Federal Register, other formal documents not published in those other locations, and just website text. And out of that, I created categories to help fit that data, partly based on categories Kent outlined in his work, but also what best fit the data. And the result from those searches are in Appendix C of the report. But my basic findings are that basically agencies already make a lot of disclosures, or at least make a lot of information publicly available, particularly in the areas of who reviews adjudicator decisions and how adjudicators are hired. but there aren't as many disclosures made about compensation, as Ken indicated, or bonuses or discipline and removal policies. But agencies also make this information available in a wide variety of ways. So currently, agencies tend to use a lot of sources that are harder for the public or really anyone to navigate. That includes, as I'm sure you're all aware, the US Code and the Code of Federal Regulations, which are not the easiest to use locations. Nor is the Federal Register, because in a lot of cases, when you search something, hundreds of results come back. And so it can be very daunting to need to scroll through 20 pages of results. Similarly, some of the formal documents like bench books or case processing manuals can go up to 200 pages, and they may not be easily searchable. So they're not the most transparent locations to provide disclosures. However, websites are a better possibility for agencies, in my experience, and for this research, partly because agencies often communicate in that format with plain language rather than relying on highly technical language. And so my basic takeaway from this process, which you'll see in the report, is that the best way for agencies to disclose information about their adjudicators is to create a short, plain language description that covers the basic information about the categories outlined in the report, and then to provide links to all the places where agencies have already made information about their adjudicators available, so that individuals who are looking for more in-depth explanations about a given kind of practice can then still get that information. So with that, I'll turn it back to Nadine.
Thanks, Leanne. That was really helpful. At this point, I guess we will just dive right in and see if there are comments or points of discussion on the report itself. You can raise your hand or put a note in the chat that you would like to unmute and speak.
May I ask a quick question, Nadine?
Certainly, of course.
Of Kent. I know there's this issue has arisen as to how many non-ALJ adjudicators there are, and maybe the answer is we really don't know, and a lot of it depends on how you count. You said that your criteria, your main criterion was whether a party can request a hearing. That would not necessarily be an oral hearing, is that right? It could be a paper affair.
Let's see, mine was whether you could request an oral hearing.
Oh, an oral hearing, okay, all right.
Yes,
okay.
and then the earlier one that Michael had done, it was whether the hearing was mandatory.
Right, by executive order or regulation or statute, okay.
Yes.
But there's a lot of porosity between the boundaries here, right? I mean, this is not an easy thing to count, and specifying the criteria is not that easy either.
Oh, that's exactly right. I mean, the first problem you will have, I think, in anything that we're dealing with non-ALJs is definitional as to how you're going to even begin to include them. And then exactly right on the next question of which factors does one think it is sufficiently important to include in something like this disclosure or further consideration for the agencies.
Okay, I see Russell Wheeler has some observations to make, so you can unmute. There we go, great. Uh-oh, Russell, we cannot hear you. Russell, hold on. No, not working. Is everybody hearing the same thing I am? Which is not Russell being as clear as I know he can be.
Yes, I hear that too.
Okay. Russell, we'll come back to you if that's okay. We'll see if, can we, okay, great. Renee Landers has a question, so I will turn to Renee.
So can you hear me?
Yes.
My question is on these non-ALJ adjudicators, is there has anyone thought about the executive order from last week and whether it would affect that category of, well, I realize, it's a very indeterminate category of people, but how that executive order might affect that part of the discussion.
Thank you, Renee. Leanne, do you want to take that one?
I don't have any particular thoughts on that, but either Matt or Kent may have thoughts.
I mean, my thought is the problem with the executive order is we don't know who's covered and who's not covered. OPM's instructions, preliminary instructions to agencies, give agencies a lot of discretion in deciding who's covered and not covered. My sort of working assumption is that most of the adjudicators that we're talking about here would not qualify for coverage under that new Schedule F, but that's just my very preliminary take on this.
Thank you.
Any other comments or questions? I know Russell's trying. Would it be helpful for Russell to drop out and come back in? I don't know if that helps reset.
I'm thinking I can, provide call-in information, or Jennifer can, so he can speak over the phone, which might be the best solution, but it might take a minute to get that lined up.
The other thing he could try in the interim maybe is to try to kill his video and see if that helps with the audio transmission, because sometimes that helps things on Zoom.
I think he's left and he will come back to us, hopefully. Any other?
May I just say one more thing in response to Renee's question about the executive order? It seems to me that insofar as that there are adjudicators who would fall into that Schedule F, that the kind of recommendation we're talking about here would operate just fine, because the agency would simply disclose that they fall in Schedule F, and which means they probably don't have MSP appeal rights and so forth and so on, and that could just be part of the disclosure.
I think that makes sense. I guess I would go back to the point that I made at the start, and it would be helpful to know Kent and Leanne's thoughts on this, is that, essentially we're recommending to agencies that they take the information that they already have currently. I mean, that might change depending on what this executive order ends up meaning down the line for agencies. But the idea is to give them a vehicle by which they can gather that information and post it so that it's easily accessible and readily understandable by the public. So hopefully whatever the executive order ends up meaning, that will be built into the process by which an agency has set up gathering relevant information and then posting it. Does that make sense? Okay.
Yeah, and the only other thing I would just add to that is, I think what's so helpful about Leanne's recommendation is this really is website based. So this would be really a liquid posting. It's something that one can update as necessary, and it won't get locked in like it might if this was something going in the CFRs.
That's great. Okay, is Russell back?
Can you hear me?
Yes.
Okay. You can't see me. That's to your advantage.
No, it's no, it's not. Go ahead. You have the floor.
Well, about the recommendations themselves, I have a variety of smaller comments, but two. One is aesthetic. There's a constant reference to the public, and I think just for the sake of the report, it would be good to recognize that we realize that there's not a lot of John Q. publics out there who are just sort of fundamentally good citizens interested in finding this information. The appendix, for example, the public it has in mind are clearly litigants, disgruntled litigants. So just recognizing somewhere that there are different types of publics. There's litigants, there's scholars, there's journalists, and others, I think would help. And second, Nadine, building on your point or someone's point that this is website based, I think the committee may at least want to think about whether putting up some sort of a website template, because a lot of this has to do with how easy it is to get to the information. Where should it appear on the website? Obviously, it could be nothing more than a suggestion to the agencies, but some indication of what information belongs on the homepage, what information should be 1 or 2 clicks away. We went through this with the federal courts when their websites just looked awful, and the one of the committees of the judicial conference developed a template, and not every court adopted it, but it tended to kind of herd these cats into a more systematic, more easy to access website. And the committee may want to think of going just beyond text to actually suggesting some website specifics. I mean, I have no expertise in that area at all, but I think just giving them text is not enough. That's all for now. I'll have specific comments if you want them.
Any feedback on the general comments? Okay. Do you want to turn to your specific comments now, Russell, or do they relate to not the report, but more the recommendation? He's quiet. Okay.
I was the comments I had would come up when we if we're going to do the line by line review that we've done for other reports. Then
Okay.
That's the whole thing.
No, we can do that. That's on the list. Okay. Any other general comments or points or questions? Okay. Trying to give enough time. I know people are typing or raising hands or whatever. Okay. Russell, since you said you had specific line by line, we will start. Let's start with the introduction to the report. Is there any thoughts about that specifically?
Well, for myself, I just again, this is almost aesthetic, but officials across the federal government.
Oh, I'm sorry, recommendation I meant. Sorry, go ahead.
There should be the page. Well, there should be some notion that we're talking about federal government agencies. It's in the title, but you don't want to get any sense that we're talking about federal courts as well.
Can everybody see? Everybody's got it? I misspoke. I meant the recommendation, not the. We got it? Okay. So the opening line, Russell?
I would just say officials across federal government agencies. Just so everybody knows, we're talking about the executive branch and independent agencies.
Anything else in this first page?
This is Judge McCarthy.
Okay, go ahead.
I think we're talking about more than just independent agencies. I think we're also talking about departments.
Yeah, I meant agencies in a generic sense.
This is Judge Sullivan. I would recommend revising this to say officials in federal government agencies throughout the country. Just a small edit.
Anything further there?
This is Anika Cooper. I thought that it would be helpful to include something about the order of magnitude that we were talking about earlier in terms of how many, like we refer to 2,000 ALJs, and then we just say as well as thousands of other. And I think the report makes it clear that we're talking about sort of many more thousands. And so I would just have something in that clause to make it clear that there are a lot more of these other category, you know, the other sort of AJ category. And the other sort of scope comment on that paragraph is, you know, we have that clause talking about not including agency heads. And I think I recall from the survey that it was excluding, I think, presidentially appointed, Senate confirmed, excluding those folks as a whole. Is that correct? Because if so, that would cover, I think, more than just not including agency heads.
I'm sorry, can you repeat? I was looking at the document. Can you repeat your question about what positions were included in the report?
Yeah, I thought, and I could be wrong, that the report, but the survey wasn't covering presidential appointed, Senate confirmed folks, period. And if that's correct, then that is broader than just agency heads, which we've carved out in that, I guess, line 2.
Nadine, if you don't mind, if I just respond to that real quickly.
Absolutely.
So I think the one thing to note is that I don't think we selected the adjudicator positions to be 100% representative of everything, every kind of position we thought might wind up in this recommendation. So if the committee winds up feeling that people who are not agency heads but may be Senate confirmed wind up here, Matt and Jeremy, you can correct me if I'm wrong, but I think there's room to adjust the scope of this as the committee sees fit. I wouldn't feel tied to the scope of the positions we selected for the report.
Got it. Thank you.
Anything else, Anika?
No, not for me.
Okay.
Well, can I just follow up on that point? I mean, agency head has this is Judge McCarthy, has a very specific meaning post Lucia. And the issue hasn't been finally resolved after free enterprise. I mean, free enterprise certainly suggests that at the in Lucia, that at the SBC, because of the Reorganization Acts, that the chairman of that agency is not the head of the agency. And I think it's free enterprise that suggests that it's at an independent commission, it's the whole commission. So I think we might want to explain what we mean by agency heads, because it's still kind of up in the air and it has a very specific meaning.
Is there a benefit to possibly using language there that signals what the recommendation is covering? So instead of, the officials addressed by this recommendation consist of, and then a footnote explaining what it's not. If there's confusion about that language and what exactly it should mean, maybe we simply say what the scope is and put the carve out in a footnote.
Nadine, this is Ken. Can I interject?
Absolutely, sure.
So maybe 2 things on this point. The idea of not including the agency heads, at least for the purposes of the report that we did, was included as a carve out to essentially track the Administrative Procedure Act, which carves out the agency heads essentially at every turn when dealing with things concerning impartiality, with the idea being that it's the agency heads that are making the final call policy decisions, and for various reasons don't need the carve outs like the underlying administrative law judge needed under the APA. So to me, if you're thinking more purposive of why we're doing this carve out, it's more or less to track the APA and concentrate on the kind of adjudicators for whom Congress has already identified some kind of concern about due process and bias issues. The second thing, just to be clear with Judge McCarthy's point, make sure we're not confusing department heads, which Free Enterprise Fund is discussing, with agency heads. One can be an agency head without being a department head. And it's the agency head that I think is more concerning for us than the department head notion for appointments clause issues, because it would be all of the agency heads are carved out of the APA's bias type provisions.
Thank you. Judge McCarthy, did you have any specific thoughts on language here that you think might help clarify the issue?
No, on further reflection, since it is a carve out, I think that my comment was premature, and I don't think there's a need to change that language because they should be excluded.
I mean, the intent here is to not capture them for this recommendation, right? The disclosures would relate only to the types of adjudicators that are noted in this second line. Is that the way we're thinking about it? I'm going to ask Leanne that.
Sure.
Yeah,
I think
I'm just concerned about the term agency heads post Lucia, because it's kind of like, in my view, kind of an open issue that's subject to litigation. But I did not look at the broader carve out of exclusion here. And even the agency heads, let's say other commissioners apart from the chairman, would not be included in this recommendation. So I think my comment was premature, so I would draw it.
Go ahead, Leanne.
I was just going to say, so based on that, are we comfortable leaving the language as is, or would we prefer, Nadine, your language with the official addressed by this recommendation to make very clear from the outset that what this sentence is doing is providing the scope of the recommendation? Like, is your language better because it clarifies that this sentence is about the scope?
I would recommend that the committee consider that, whether this is the place to do that. As it stands right now, this statement is simply a general statement, obviously flowing from the first statement, which is very broad. It's a very general, there's a lot of adjudication going on in the federal government, and it's being decided by officials that consist of ALJs and others, but not agency heads. So the implication there is that agency heads never make these types of adjudications, and I'm not sure that's what we want to say either.
Nadine, if I may, the other thing here is, we're sort of thinking of the agency head as the person at the very tippy top of the department, or and you have agencies within agencies, administrations within agencies, and those people could very well be characterized as agency heads, and you may very well want disclosure of the terms and conditions of employment under which they work as well, and the way and manner in which they're appointed and so on. So this might be a complicated issue here. And I think I would advise the committee to sort of consider what the purpose of the exclusion is in deciding who should be excluded exactly here.
Can I just add one more thought?
Sure. Go ahead.
Agency heads can supplant the first line, let's say administrative law judge under the APA, to make the final adjudication in lieu of the administrative law judge. I believe, can they not? So, I mean, technically they can stand in the shoes of the adjudicator if they opt to do so. As a practical matter, they don't opt to do so, but the APA permits them to do so.
What about what happens if the agency head delegate is making decisions on behalf of the agency head, which happens all the time, at least at higher level reviews, beyond the hearing level? Might want to know who those people are too.
I guess I was focused on some of the samples or examples that Leanne included, which focus largely on the ALJ, AJ component, which I view as, you know, in a roughly easier category than determining who may or may not be an agency head. I welcome any discussion about the scope and what the best approach is here in terms of the disclosures that we're looking for.
Hi, this is Roxanne. I put a comment in that I have a comment.
I see that. Go ahead, Roxanne.
When we were doing the project on recusal, we discussed at length something very similar, which was we initially started out from the perspective that the recusal recommendation would not apply to agency heads. And after much discussion similar to this, we, I think, ended up deciding that it might or it might not, depending on what the agency was and how they were structured, et cetera. And we, I think, we did it as a footnote saying, you can decide for yourself whether it applies to your agency head. So for example, I'm with the National Labor Relations Board. Our board typically does not act as an adjudicator, but we do have a procedure by which the parties can bypass the administrative law judge phase and go straight to the board for decision. And in that circumstance, the board is making the initial determination. And in looking at Kent's report that was contained in the report, the actual last page of it, which contained the 8 factors that he recommended be disclosed about agency adjudicators. For our agency, I don't think it would be a bad thing to disclose these 8 things for our board members because it covers things like, you know, is ex parte communication prohibited, et cetera. So I think it may depend from agency to agency whether or not it should be applicable.
I think we can look back at that. That's ringing a bell, Roxanne. Do you have any specific language suggestions here other than maybe just a placeholder for looking at that approach that we used previously?
I think I'd just suggest a placeholder till somebody can take a look at that because I think
Okay.
it might have been just a footnote.
Okay.
Nadine, I mean, I assume
Matt.
it's, I've heard some comments that sort of maybe suggest a little bit to the contrary here, but I mean, appellate adjudicators, to refer to the next project we're taking up, I mean, people who hear appeals in agencies are adjudicators, and presumably that they're by and large covered by this recommendation, and they're very often agency heads, especially at places, say, like at your agency or the NLRB. I mean, that's all the NLRB, and they do a little rulemaking, but they're adjudicators mostly. And what would be the principal basis for excluding agency heads who are adjudicators?
Nadine, also, I just wanted to flag Gavin put into the chat the exact language from the recusal rules that Roxanne was talking about.
Yeah, if everyone could take a look at that, I think that would be helpful to illuminate the point Roxanne was trying to make. It specifically indicates that it does not apply, but it gives the agencies the flexibility to do that if they want, to disclose that. So this, of course, would be disclosing that information about their agency heads.
There were reasons for excluding agency heads in the recusal recommendation that may just have no application here. I don't know, Reeve, do you have any thoughts on that, or Jeremy?
Not really. No, I think that that's exactly right. I mean, I think that they're sort of differently situated, so we'd have to sort of think through explicitly within the context of this, you know, when it may have applicability at agency heads and try to capture that in the language. But I don't really have any further thoughts beyond that.
Well, sorry to jump in. I'm not on video, so I can't raise my hand. This is Roxanne again. I think Matt makes a very good point. There are certain agencies like my agency or Nadine's agency where the agency heads exist for the purpose of adjudication. So excluding them for us wouldn't make or it would make sense to include them in this sort of disclosure, I think. Just that's my initial thought on it.
Yeah, I would just add 2 points. At least one purpose for excluding it was exactly what Kent mentioned earlier. The APA has this distinction between line adjudicators where we have concerns about impartiality and agency heads where you can actually combine functions. And the point, just echoing what Roxanne just mentioned, there is a variety of roles for agency heads in adjudication. The Attorney General in the immigration system is obviously situated very differently than the NLRB in labor disputes. So there is just wide variation there. But as to the scope, I leave it to the committee.
This is Kent again. Just one quick interjection. One difference too to keep in mind is just what the purpose of this recommendation is. So for instance, we tried to only include appellate adjudicators in our survey that could take evidence from time to time. And so that was part of the definition. And part of the reason we were doing that and trying to exclude the agency heads from it is because we were trying to get a better snapshot of the entire non-ALJ community. And if you wanted to compare kind of apples to apples, it wouldn't make sense, for instance, to ask whether the head of the agency had separation of functions, because of course they're going to have combined functions, where we wanted to try to get somebody below that level. But if the point here is not really to do this, comparison of data, but instead to disclose exactly what's going on in each agency and what kind of impartiality each element of the adjudicatory process has within each administrative regime, then it makes more sense to me to include them.
I mean, just further to Kent's point, it would seem to me that, often the people who are reviewing hearing level decisions are the most unknown to the public. The sort of, you could call them intermediate appellate reviewers, whatever exactly you want to call them. And it would seem to me that in many cases you would want to know information about those adjudicators. Like, why, for instance, would you not want to know in the immigration system? You would obviously want to know about your immigration judges, but wouldn't you also want to know about the judges on the Board of Immigration Appeals? And I don't, and I think I'm saying largely the same thing as Kent. If the purpose is, as Kent sort of stated it, it would seem to me very unprincipled to exclude people who are, or to include only those who are ALJs or basically hearing level adjudicators. The Appeals Council at SSA, another good example.
Any thoughts on that? Whether the scope should not be limited? I'm seeing nothing. Okay. So is it possible then to craft this second sentence, if indeed we want to make this second sentence do that work in terms of what we intend to cover here? The officials addressed by this recommendation include, and then have the list. Agency heads, the roughly 2,000 administrative law judges, as well as the thousands of other adjudicators referred to as AJs.
I have one other question, Roxanne.
Yes.
So on the opposite end of the spectrum of the agency head, Kent had said that in the survey they found that there were 23 different titles for people who do adjudication. So I take it that from phrasing it the way we are in this introductory paragraph, we are excluding everyone who isn't called either an administrative law judge or an administrative judge. We're excluding hearing officers and all those other folks.
Well, the footnote 3, is it? Explains that there are other titles for those folks. I think we're including them.
Okay.
Yeah, I think we're including them.
Okay, gotcha.
Any thoughts on the new sentence that, I hope everybody can see that. I'm seeing a positive comment.
Sullivan, I think it works just fine, thanks.
Any other thoughts? Judge McCarthy, did you have any? I don't see, is he still there? I think he's still there. Yeah.
Or it says the thousands of other agency adjudicators referred to as administrative judges in this recommendation. Who are these people? It doesn't refer to anything.
Yeah, I was going to flag that. You got ahead of me, Matt. I was looking for a source for that.
Sorry, I just want to I just also want to throw out here that this is not to leave both of these sentences in. I think footnote 3 would still apply to the end of that sentence. Like those footnotes would still be in there. I just didn't want to delete the footnotes in the process.
So I just didn't know, and maybe Leanne, you are the best person to ask about this, if there's a way. I mean, obviously footnote 3 gives the other labels for the other position titles for individuals that we're going to collectively call AJs. But the thousands of other agency adjudicators, is there a source for the thousands that we could throw in there?
I think I would just cite Kent's report for that. That seems like the easiest solution.
We can't do that, Nadine. That's not a. We have to. I think we.
No.
Reeve, why don't you jump in here? I hate to be too difficult on this, and I'm not a member of the committee. I'm just offering my opinion. But it seems like we have to, at no matter what level of generality, tell the agencies what adjudicators we're talking about here. We can't just say go see Kent's report. That doesn't work for a recommendation. But we have to be forthright and upfront about who's covered and who's not. It may be that it will have to be a somewhat general statement as to who's covered, but simply to send a reader to Kent's report, I don't think is how we would normally draft a recommendation. Reeve?
Yeah, I agree with that. And I think we can be pretty general. I mean, it sort of seems like there's sort of two issues here. One is, the titles. I think that's easy enough to address in the footnote, but there's also a question of sort of which types of adjudicators are covered and which aren't. I don't think we can really go to like sort of the type A, type B, type C either. I think we're going to have to sort of be somewhat precise in terms of, the adjudicators that conduct the following types of hearings fall within the scope of this recommendation. And then, other things may fall outside the scope. And I think we can keep it at a high level of generality, but I think sort of to be sufficiently precise, that's something we'll have to do within the language of the preamble here.
Can I make a suggestion?
Sure, go ahead.
So it seems to me that something like changing that one clause of the sentence to thousands of, I like the word additional better than other, but and thousands of additional agency adjudicators, including, and then list the ones that you list in footnote 3 right there, hearing officers and so on, which are referred to in recommendation as administrative judges. Does that help?
I think that's helpful. I wonder if there's limited benefit to saying how, and do we need to say 2,000 and thousands, and as opposed to just the positions that we're talking about here? Include agency heads, administrative law judges, and the additional, we're missing some language. Yeah.
Additional agency adjudicators, I would say.
And additional agency adjudicators, including.
Nadine, this is Judge Manuel. Yes. Would it be helpful to identify agencies? Certainly not all of them, but we know that there are certain specific agencies that have vast numbers, hundreds. So just as an example, kind of a EG Could we say the Commerce Department, the patent judges, the NLRB, the Veterans Administration, immigration judges, Department of Justice, but there are certain, you could list a handful of agencies that themselves would have collectively thousands of AJs.
I think that, I mean, that could either be, you're suggesting it should be in the text as opposed to maybe in a footnote. I mean, there is a footnote about, you know, the vast majority of ALJs are in SSA. Perhaps there's room to build in to that footnote, the corollary to that on the other additional agency adjudicators. Some examples there.
Or how about just in addition to footnote 3, as an example, e.g.
So that would be right in the footnote. Footnote 3.
It's just one further way of describing it, because I agree with Matt's initial comment. It seems kind of amorphous that there are these sort of titles, but you know, you almost want to ask the question, well, who are these people?
Mm-hmm.
Where do they work? And rather than trying to describe the nature of their work, which could go on ad infinitum, one example I try to use in these situations, I think is helpful to people to get some sense of the work, is the Nuclear Regulatory Commission has AJs. And it provides a sense of, you know, the kind of work that AJs do.
This is Kent. If it's helpful, in the report that we provided, Figure 1 lists all of the agencies that reported non-ALJs and also lists the numbers. So if you wanted to do an example out of that, let's say take the top 5, it's got it listed which ones those are. And you could also include, if you wanted to, the examples that Michael Asmo used for his at least type B proceedings. I think he concentrated on 8 of those, if I recall. So you could just take those as examples as well if you wanted to add to it.
Can I ask a clarifying question real quick, which is, I think at this point, is the current suggestion on the table that we're putting into the sentence the titles which are currently in footnote 3. So we would remove those from footnote 3 and then make footnote 3 a list of representative agencies instead on that sentence?
I would say do both.
Well, I think we have the list. What if well, I was going to suggest additional agency adjudicators and take out the list and leave it in the footnote. Is there any other, I know Judge Manuel would prefer to keep the list in the text. Is there any other thoughts on that?
It might be helpful, Ken. I think you mentioned earlier a definition you used in your earlier writing about who we're talking about when we talk about AJs, something that sort of unifies all of these things. What was that definition?
Keeping in mind that he's excluded appellate adjudicators, which are very important.
Yeah.
Yeah, so, and it just shows you part of the problem of this is just how long the definition is to try to get them to us. It says one of the parties to the adjudication can, by statute, regulation, or other law, obtain an oral hearing over which an agency official presides to present evidence, even if most matters are handled through written submissions without an oral hearing. And the presiding agency official is not a member or commissioner of the agency and is not an administrative law judge. Instead, the agency official goes by another title, such as administrative judge, administrative appeals judge, administrative patent judge, board of contract appeals judge, veteran law judge, immigration judge, presiding officer, hearing officer. The relevant oral hearings do not include public hearings in which members of the public are invited to make statements or an initial frontline agency decision when the initial decision is followed by an evidentiary hearing before an agency or court.
Whew, that's
Nice
a
and
lot.
pithy. Yeah.
What if we're afraid of leaving somebody out? Is that, I mean, additional agency adjudicators, comma, such as, so that it's clear that we're not necessarily capturing everybody there. And then the footnote could, I don't know if we need to replicate the list again in the footnote, but I like the example of putting, you know, the idea of putting some examples of what agencies these people, you might find these people at. Any thoughts on that? So footnote 3 would come at the end of this new sentence that we've been working on. I realize it's at the other sentence right now, but any thoughts on this language?
This is Roxanne. Oh, go ahead.
Go ahead.
Yes, Roxanne.
One thought might be is where the sentence currently states, as well as thousands of other agency adjudicators, and put a period there, and then start a new sentence saying, these agency adjudicators can go by a wide variety of titles, including, and give the examples that you're giving here, and then the footnote, and then at the end we say, for ease of reference, we will refer to them as administrative judges, AJs in this recommendation. So that goes to the end. And then the footnote can state the examples of the adjudicators at the particular agencies.
Okay, I'm going to rewind you. Let's go back because that was a lot. All good though. So if we work with the new sentence, which I'm not sure if you're comfortable, if you're talking about the new sentence that's in paren right now, that's at least all in red on the screen I'm looking at.
Yeah, so basically we'd put a period at the end of adjudicator. No, actually, no, I meant up 3 lines where it says, as well as thousands of other agency adjudicators, and put the period there.
So you would work with that sentence as opposed to the sentence that follows that is the one we were intending to replace that sentence with. So.
Oh, maybe I wasn't following the editing then.
I apologize. Until we decided on which sentence was better, I was leaving the previous one in primarily for the footnotes, so we didn't lose the footnotes. But I think we had talked about removing the numbers from that previous sentence, so I restarted that sentence as the next line there. So I think,
yeah.
Your current recommendation would have the period there in the new sentence, I think.
Okay, yes.
And then there would be a new sentence. Why don't you strike that out for now? Yeah, if you could just, maybe that would help. It doesn't mean we can't go back to it. There we go. Okay. So I'm sorry, Roxanne, the new sentence.
Sure, the new sentence would be, so an additional agency adjudicators, period, which you've got the period now. Then the next sentence would start, these agency adjudicators go by, we can say it better than this, a wide variety of titles, a variety of titles. Sorry.
That's fine.
Such as hearing officers, immigration judges, and then what you've got listed there. And then just says which are referred to as magistrate judges in this. I would be in favor of saying something such as which for ease of reference will be referred to as, or something like that. Just explain why we are lumping them all under some administrative judges.
I think when you initially stated this, you had that last clause as a separate sentence. Do you still want that, or do you think it's better combined with the current sentence as it is?
I think it can be in one sentence, and then the footnote 3 would move here, but then footnote 3 now, since it wouldn't just be a list of titles, since we have it in the text, footnote 3 could contain those examples that you were talking about.
Yeah. Any thoughts on this proposal?
My only thought is, and I think it's fine if it may be the best the committee can do, but we are not providing a definition here. We're just providing examples. And, it's not like a general definition followed by a bunch of examples. We're really leaving the question unaddressed, and we're leaving it in agency hands to decide which adjudicators are in and which are out. And we're not defining it by reference to say any of the criteria that Kent mentioned. That may be the best the committee can do, but I think that's what we're doing here. We're just giving examples. It's like definition by example. And then you have to decide, by analogy, is an adjudicator close enough to one of these adjudicators here to be covered? Maybe that's the best thing to do, is just you're basically leaving it in the hands of agencies to decide who's in and who's out.
I wonder how many though would be out.
Well, can I say in response to Matt's point, is there anyone who's done one of the prior reports on adjudication think of a short and pithy definition of adjudication that would work here? That would be maybe the second sentence in this after the second, we could use the second sentence in this paragraph.
Here's if you want to, if the committee, and I'm not necessarily recommending this, I see some downside here, is if the committee wanted to have a fairly precise definition, it could do something as we've done in other recommendations. And I'll just use Mike Asimov's shorthand. I don't recommend that we use type A's and B's, but that the recommendation covers those who provide over hearings in type A and type B adjudications, and those other agency officials who review their decisions on administrative review. That would be a very precise definition in accord with some earlier ACUS recommendations. It would exclude the type C adjudicators, and then you could presumably have a sentence that says agencies may want, on a case-by-case basis, to include some adjudicators who don't fall within those categories. That would be one way of doing it. There are several ACUS. Reeve, are there, or Jeremy might know, are there recommendations where we've done that?
There definitely, I think, are recommendations where we've done A and B. I don't know that there are any where we sort of said that with respect to C, that, it's sort of an agency by agency determination. But, yeah, I think we basically use something like the Asimov framework. I want to say in recusal and, a handful of other past recommendations. So I think something like that would bring greater precision.
So you would, if you didn't want to use the type A's, what you would do is say any hearing, any adjudicator who presides over a hearing governed by the formal hearing provisions of the APA, as well as any hearing, any judge who presides over an evidentiary hearing required by statute, executive order, or regulation, and anybody who reviews the decisions of the foregoing. That would be the most, if you wanted something neat, that would be the neatest way to do this. I'm not, just offering as a possibility.
So the idea would be to get away from these titles, names, labels, and focus on what they do as opposed to what they're called.
Right, and but will you what they do would be sort of listed as the definition. There's no reason though that in a footnote or otherwise you couldn't still give some illustrative examples of who these people are: immigration judges, appeals judges, whatever, patent judges, so on and so forth.
Any thoughts on that? There's the length. Yeah, go ahead, Leah.
I'm sorry, you were going a little fast, Matt. Could you repeat the second half of that after, as well as any judge who presides over a hearing as required by?
Yeah, well, all right, so you've got type A, which is, let's break this down into two parts. One, those who preside over evidentiary hearings, and those who review the decisions of those people, the appellate reviewers. So in category one, you'd have ALJs, and Jeremy, jump in if I'm messing this up. In category one, you have ALJs, as well as any official who presides over an evidentiary hearing required by statute, executive order, or regulation, right, Jeremy?
Yes, I believe that's correct.
And then in category 2, you would have any official who reviews a decision of a category 1 adjudicator. That's about the best I can do.
Yeah, as to what that leaves out, I guess, for the committee's consideration would be these sorts of fuzzy type B, type C adjudications where A, it's not legally required, or it's an option. Also ones that are not necessarily characterized as evidentiary hearings, which include patent, IRS, appeals officers, those sorts of things.
Yeah, and you could have a catch-all statement that agencies may also wish to include adjudicators who preside over, I mean, you could have some weasel language here, preside over hearings of sufficient formality to justify disclosure, something like that. I don't know.
So this is Roxanne. I think that's really good. I think by rewriting it the way we did, we lost from the first sentence where we even just said conduct hundreds of thousands of adjudications each year. We lost that part. And so that was like the minimal amount of definition that we were providing to what it is these people do. I like the more specific definition that Matt has stated. It makes it a lot easier. You know, we can still say, for ease of reference, we are calling all these people either administrative law judges or administrative judges, something to that effect. I think it will be very helpful. Oh, and my other question is, in changing this all around, are we losing footnotes 1 and 2? I wasn't clear.
1 is definitely still in. I currently have that the first sentence is staying in. It's the second sentence that is gone, I think. Footnote 2, I think we can still keep in wherever we discuss ALJs. I don't think anyone wanted that removed, just that it was going to have to wind up somewhere in the new reframe sentence.
I think that's true.
Okay, thanks. Yeah, I wasn't sure what was going, what was coming, but I see now you've got struck out what is going.
Any thoughts on the language? I think it's in the comment right now, but we could pull some of this in. I'm trying to think of how to formulate a sentence that would either replace the red line sentence that's there now or build from it.
I'm also unclear on the ordering. Do we want the definition of adjudication after that first sentence that says conduct hundreds of thousands of adjudications each year, and then keep in a sentence that says the officials addressed by this recommendation include, like we already have with that bit? I wasn't sure if we're adding an extra sentence or replacing an existing sentence, basically.
I'm trying to decide as well, does it make sense to include that language before what we have suggested here or after? So the first line is about officials who conduct hundreds of thousands of adjudications. The next line could be what type of adjudications we mean, and then the third could be who actually conducts them. Any thoughts?
Although the categories that are in the chat or in the comments area are talking about the categories in conjunction with who holds the hearing. So it may be we have the first sentence as is at the top here, and then we say then we go into the officials addressed by this recommendation include those who conduct the following types of hearings, and then we go into what the hearings are. And so that would replace all of the stuff that's highlighted.
So again, defining them by what they do as opposed to what they're called.
Right. And then we're just acknowledging they can be called. acknowledge that they can be called a lot of different things, but oh, maybe that's what we should say, is the officials addressed by this recommendation may have a variety of titles in different agencies, but they perform the following types of hearings, or conduct, I should say, not perform, conduct the following types of hearings, and then we put in the definition. And I apologize if I'm just thinking out loud here, but it is trying to see how we fit this all together.
This is Judge Sullivan. Could you write it so it says, but they perform the same essential adjudication functions? Or would that be too broad?
Can we
You
try
could
that?
say that. You could say that they perform the essential adjudication functions, including, and then go into the definition.
I can't see the comment any longer.
Yeah, I'm having, it won't keep the comment open
Yeah.
when I'm typing in line, unfortunately. I can copy this into the main body of the.
Why don't we do that, and then we can fix how we want to phrase it.
Okay. Sorry that this is the messiest thing ever. But I feel like keeping up prior versions is proving helpful because we are still stealing language from previous sentences.
And then we would say such as evidentiary. Is that the idea, is that we would be more, this is illustrative, such as evidentiary hearings?
Yeah.
Required by.
And should we, I think we also need to cover the APA formal hearings, right? Because we're including ALJs in this part of the definition as well.
I believe so. Well, if you say required by statute, executive order, I mean, that would.
I don't think the word recommendation is what I meant to type here. Regulation, maybe?
Maybe. Let's try it.
Yeah, it was regulation.
Okay. I'm not sure that's sufficiently specific.
I think for now, let's use that as a placeholder, and then
and is Matt's suggested catch-all a footnote or in the text?
Any thoughts to the crowd?
What was the catch-all text again?
It's on the screen. Agencies may want to include adjudicators who preside over hearings of sufficient formality to justify disclosure.
All right, I was looking in the comments area again. I would include that. Not in, I mean, I would include it in the text, not necessarily just in a footnote.
Is the document frozen or is that just me? Leanne? Leanne?
I think it's frozen.
Okay.
Let me
lost
try
you.
turning off my webcam to see if that helps
Okay.
the internet speed. Can you still hear me though?
Yes.
Yes.
Okay.
Did that help unfreeze when I turned off my video?
Yes. Okay. So I think.
Okay.
It seems that we're covering, I think we're all in agreement, at least I'm not hearing objections on using the functions as a way to help define what we're covering here. And then we can use the language that we've already got here about, what do we call these people who do this work?
Yeah, can we talk about where to insert the existing footnotes 2 and 3 and if we still want them?
I think the footnote 2 would have to be somewhere in that bottom part where we're talking about ALJs, right? Because that's giving an example of where most of them work. And then footnote 3, I can't see that right now on the screen, but footnote 3 would have to then go with the other, that new sentence that we have there. I think that these agency adjudicators go by a variety of titles. So
Does where I put that make sense then based on what you're saying?
sure. Yep.
And I guess, forgive my confusion, are we keeping what's now a new paragraph just for ease of, is that going back in the footnote or is it?
Okay, we are breaking up a little bit there. I think we can look at possibly putting it in a footnote. I think that we'll have an opportunity to look at this again, but I think hopefully we're at least addressing kind of what we think this is covering, and we can use those examples. Is she frozen? Are you frozen, Leanne? I don't know if she can hear me.
Yeah, I think those examples would go into footnote 3.
Yeah, I'm still here. I turned off my video to try and help with.
All right, good. Yeah, I think if maybe just include a comment there that we can drop those down in, and maybe that's something that can be done.
I can also undo the deletion we had earlier, right? Because we originally had those titles in footnote 3. And so if we just put that back and include the representative agencies in that same footnote, does that seem correct?
I think that works. And we can,
okay.
We don't necessarily need to spend that time now doing that. If you want to make a comment so that it's clear that that's going to be done, and then we can look at it all clean at some point. We'll have an
let me
opportunity
copy
to
this
revisit
language into a comment and then get it off the screen, perhaps.
That works.
And I think given how we've now edited it, and I might not be tracking exactly, but I think we've now lost in the main text that we're basically saying, and we're going to call these people administrative law judges or administrative judges. So I think we can just close with a brief statement at the end of the after agencies may want to include other adjudicators who preside over hearings of sufficient formality to justify disclosure. I think if we then just close with a brief statement which says, which Leanne's a step ahead of me, for ease of reference, we will refer to these adjudicators as administrative law judges or administrative judges in this recommendation.
I think that makes sense. Okay. I think since we spent quite a bit of time on this opening paragraph, before we go into the next one, maybe we can take a short break. We're about halfway through our time together, maybe a little past that. And it might be good to get coffee, get water, bathroom break, whatever all you need to do. And maybe we can come back at 1:45.
Thank you.
Leanne, does that make sense?
Yeah, that works for me.
And then we'll plow forward. All right, great, thank you.
And I'll
This
just turn off my
conference will
video.
now be recorded.
I think my computer is having trouble both sharing my screen and sending video.
Yeah, I think we've seen that before with some of the other, not with GoToMeeting, but with other platforms we've used. Not a problem. Get everybody, I'm trying to see. We have everybody.
Nadine, I said that Reeve and I were talking before this whole project or the committee meeting arose, and we said that this is going to be the hardest recommendation of all of them this fall. Wait till we get to the other stuff. So anyway, so that's why we're so glad to have you chairing the committee. But I think you'll get this done in 2 meetings.
We'll get it done.
All right.
I'm glad we're on the recommendation. That was a good. Okay, let's get started then. So. I think we should leave this first paragraph for now. I trust Leanne to kind of smooth it out, and it's not set in stone at this point. So let's move on to the next paragraph, which I think starts to set out the reason why, maybe if you put a page break or something there so that we could see that whole paragraph on one page. Would that be possible to do?
Yeah.
Yeah, that'll just be better. Okay. Anything on, let's say, the next 2 paragraphs? Why don't we try to?
I do not. This is Russell, Nadine. I have some comments. Can you hear me?
Yes.
This does go to, I don't think it's anywhere substantive as the last paragraph we were talking about, but it does go to, for whom are we doing this?
Mm-hmm.
And I don't think ACUS wants to leave the impression that we think there's some large cohort of just public citizens out there who wake up in the morning and say, I really need to know more about how immigration judges get disciplined or something like that. So I would suggest the following. I would break the first sentence into 2 sentences, and I would say something like this. Various elements of the public, litigants, but also attorneys, journalists, scholars, and others have a benefit from having so and so and so forth. And then on the next line, the sentence would begin, they also, and then the third sentence, just parallel construction. The public availability of these policies, practices promotes public confidence, so on and so forth. And then I would say, and promotes public understanding of adjudicators' constitutional status, et cetera, et cetera.
Can we go back up to the first line? I think you're moving quicker than Leanne can type.
Sure. Well, I mean, the question is whether people want to pursue that, whether they think it's worth doing. If they don't, I'll persist, because that reference to the public, this sort of undifferentiated public, persists throughout the report. And I think we're really concerned primarily about litigants. That's the audience for the suggested language in Appendix A. Clearly, that's who it has in mind. It's not the only one that we are concerned with, but I think we want to be a little more specific about for whom we are doing this. So if you want me to go back, I will go more slowly over my suggestion.
I do think that that's who the audience is here. There is an indication, as we say later, that agencies can benefit as well.
Agencies can benefit, and journalists who want to know more about it, and scholars, of course, but it's not just the public, as if a lot of John Q and Jane Q publics are sitting there following this stuff, with bated breath.
Why don't you go ahead and propose your language, and we can go from there.
Then what used to be line 5 that begins just as, I would say instead, various elements of the public, litigants, but also attorneys, journalists, scholars, and others, dash, and then continue the sentence up to the words governing them, period.
Can you give me the language? I have various elements of the public, and you suggested a dash there.
Litigants, but also attorneys, journalists, scholars, and others, dash.
Great.
Benefit from having, and then no changes until the next line, governing them, period.
Okay.
Then capital T, they, capital they, and that sentence stays the same. And then to get rid of the reference to the public and to create parallel construction, the last sentence would read, the public availability of these policies and practices promotes public confidence that administrative adjudicators are impartial decision makers and promotes public understanding of adjudicators' constitutional status. I have a hard time seeing the document. It's very small on my screen, but
I think I have your changes in correctly now. Thank you for going slow for my typing speed.
No, that's okay.
Any thoughts on Russell's suggestions here? Hearing none, we'll move on. Anything else in this paragraph? Oh, that's great, Leanne. Did you just make that much bigger? It looks
I didn't
bigger on my
intend to.
screen.
Did I accidentally do so?
No, but it's good. At least it's good. Now it's smaller.
Okay. Oh, that's small. Okay, wait. I'm playing with things, so maybe this will help. We'll figure this out. Does that help?
I think it's larger. I don't, for those of you who need it to be larger, it's helpful. Okay. Anything further on that paragraph? I'm hearing nothing. Nothing. Next paragraph, agencies also benefit from. So this is the idea that agencies can compare and learn from the other agencies.
It is Russell again. On the third line, I think those is a little unclear. I'd say including practices required. And then the next line, more cost effective than what? I don't know what the reference is.
Well, I think
More cost effective than non-website disclosure or something like that?
Well, I think the idea is proactive disclosure, so that, you know, the idea that you have to request something and then it has to be processed, as opposed to proactively disclosing it, which saves the agency money. I think that's all we mean there, but Leanne.
Maybe more cost effective than agencies responding to individual requests.
And not that it's necessary to add a citation, but Professor Margaret Quokka has made this exact recommendation in other FOIA matters where there's been so many requests for individual requests. She says start posting this stuff on the website where it's essentially high demand disclosure. So it would be consistent with some other approaches too.
And there's definitely, you know, DOJ, Office of Information Policy, and the eGov Act itself. I mean, there's a lot of discourse around the idea that agencies should be proactively disclosing information.
This is also a big issue for some of our supporters on the Hill. So,
anything further on that?
I had a very small.
Okay, hold on. Is that Jack?
Yeah, I'm sorry. I had a very small suggestion on this. In the first sentence, I would say agencies may also benefit by comparing their own practices with the policies, or can also benefit by comparing Instead of from, I would say by. Comparing.
Jack, I had the exact same edit on mine. Perfect.
Okay, good. So we can share the ignominy.
And this is Roxanne. My question was about the same sentence. The last part of the sentence says, and by learning from their experiences. I'm not sure what that means. I'm not sure what they are learning. I totally get the value from comparing to see what others' practices are.
Are you suggesting taking that out? I think it's largely redundant. What we intended when we wrote was largely redundant with the first half. Is just like, by comparing, you may see better practices and learn ways to do new things.
Yes, if that's what it was intended, I agree. I think the value's in the first part of the sentence.
Okay.
Okay. Anybody else on this paragraph? All right, we'll move on then. Next paragraph.
Although they're not needed, I think semicolons might work better setting off these various individual items. I realize there's not commas within it, but there's such a long string. I think a reader would benefit from having a semicolon that would clearly differentiate these discrete items. Just a thought.
Great. Okay. Next paragraph, unless there's anything on that. I like when it's just semicolons. We can deal with that. Okay. Many of the policies, this paragraph. Okay. Paragraph after that, further ALJ's makeup.
My only suggestion in that paragraph is about halfway through, where it says some relevant sources may not be available to the public. Again, that's that same mythical public. I'd say may not be publicly available.
So I think what was, okay, yes, that makes sense. Sorry, I was on the wrong sentence.
I wondered if that last sentence there could be either the point could be merged into the prior sentence or phrased in a way. I don't know. Maybe I'm taking it too personally, but it sounds like taking agencies to task for not doing that. Could you add it to the list of things that might not be publicly available?
Sure.
It's a sentence based upon Leanne's research.
Oh, no.
Yeah. I just worry because those are two different, one
You're
is
right.
categories of information.
I
one
see that
sources.
now. Yeah, you're right.
If there's a better way to word that sentence so it feels less confrontational.
No, maybe it's just me, but maybe if you make it passive. I think everybody knows who we're talking about. Oh, Judge Manuel, do you have an idea?
What about many agencies do not publish or do not, basically cause it to be readily available is the point you're making earlier, or have not published.
Have not published?
Or choose not to publish.
I also want to point out, while this is a point from my report, what I cabined specifically is also that I don't think it's out there, but it may just be really hard to find. So have not made readily available or easily findable might also be a way to frame this instead of saying categorically we know they haven't disclosed it.
You could make it passive by just saying are not available rather than saying who's not making it available. Certain kinds of information is not generally available, and you don't have to blame the agencies then, although it's implied.
I think that's good. Anything further on that paragraph?
What about this is particularly true with certain kinds of information?
I like that better because the way it was phrased just now made it sound like it shouldn't be. Like certain kinds are not available, especially those about compensation. That makes it kind of sound like it shouldn't be available. Whereas this new phrasing, this is particularly true with certain kinds of information.
You can take out the are not available.
Yeah.
Yeah, I like that. Good.
This is Ken. Just one question. It's not suggested language, but in our survey, we found, as I mentioned earlier, quite a bit of the provisions were reported to us as arising through custom. Indeed, like through the separation of functions, most of it arose through custom as opposed to anything specifically that's being enumerated here. Is that something that we want to reference to, that they're governed by unwritten custom?
Any thoughts? Okay, I think, we can leave it as is. I think that's something to think about, Ken. But
This is Jack again.
Yeah.
And as that last sentence is rewritten, would it be better to use such as those instead of especially those? Because we've already got particularly in the first part, so these are the examples of the ones that are particularly. That better? I'm not sure, but it seemed better to me.
Yeah. Okay. Next paragraph.
Russell again. Instead of members of the public, I just say interested publics or interested parties or individuals most naturally seek.
Did you mean interested individuals or just the word individuals?
Either one, anything except members of the public.
Right.
I like individuals. I think that's good. I wondered, we referenced plain language there. Don't we have a recommendation on plain language? I'm looking to my ACUS folks.
We do. You're suggesting maybe dropping a footnote, referring to that, just, maybe guided by the principle of plain language.
Always ready to tout our ACUS work, conference work. Why not?
Absolutely.
Yeah. Okay. Anything further there in that paragraph? Great. Next. Okay. This is the sum up before we get to the recommendations. Anything here?
Again, this Russell, we're talking about the paragraph that starts this recommendation.
Correct. Yes.
I wonder about the 4 lines down. It said it's already publicly available. Agencies will not face a significant burden implementing it. Only need to reorganize some of the content already located on their websites. That may understate considerably what's involved here, which is a redesign of the website, which isn't the easiest thing in the world. I don't know whether I'd say, the job is almost done. You just need to put this stuff or put it on the website. Where's it going to go? Is it going to be prominently available? How's it going to be arranged? I mean, what we're talking about here is making stuff not only available, but more readily available. And that does go to website design. Again, my experience with the federal courts, people thought they'd solved all their problems. They stuck something in a PDF document and put it somewhere where if you look real hard, you could find it. So we may be understating what agencies may need to do in order to really meet this, not only the letter, but the spirit of this recommendation. Having said that, I don't have any suggestions about website design, but I don't think we should, at least I suggest the committee consider whether it's quite as easy as it may be implied here.
I guess I read the line. I think there's some indication that agencies have this information. It's scattered in disparate spots. And so I think what's being said, or what's meant by what's being said here, is that some of this information just needs to be gathered together. It's already out there, but it's not organized or presented in a way that's helpful. You could kind of hedge it and say, to the extent a significant amount of this information is already publicly available, agencies need only, I don't know. You know what, I understand what you're saying. You don't want to make it sound like it's like super easy, snap your fingers. For some agencies, that might not be the case.
Yeah, I mean, I don't know exactly what the language is, but what are the criteria here? It's really, if someone wants to know these things, they go on the website, and how deeply do they have to dig into it to find this? So lines like, prominently displayed on the website, or displayed without, displayed in common sense format or sequence, something to indicate that you don't really meet the spirit of this simply by taking a bunch of stuff and putting it somewhere on the website.
This is Roxanne. Do we need that second sentence at all? I mean, I know it talks about it not being a significant burden, but do we have to reference that? Because if we took that sentence out, we could just go straight to this recommendation, and then I'd get rid of the word simply. Maybe that's sufficient.
Well, that's fine, but then you get into the question of explain. It's not merely a matter of explaining, but it's a matter of displaying. I mean, the explanation can be simply stated, but if it's buried somewhere where you have to, be a website sleuth to find it, you haven't really met the spirit of the recommendation.
I think you could take that sentence out and build into, I think you've hit right on it, Russell, where, to gather relevant information. You're trying to convey some of the steps an agency might have to undertake to create this explanation, or not create it, to give this explanation.
And maybe we could change the word explain to disclose.
Well, I would, rather than explain or disclose, I would say to present in a readily accessible manner, something like that. I mean, all we're talking about here, when you go on the website and you see a few things up on the top bar, and you ask yourself, well, where do I have to go to find this? It's a matter of, it takes some skill to create these. And I don't think we want to leave the impression that you can just ask, the agency head's nephew who took a course down at the local junior college, here, fix this for us. It's a little more complicated than that.
This is Jack again.
Yes, Jack.
Chime in on this. I thought that the sentence that says this recommendation encourages agencies, I would start with that. I would start the paragraph with that. I would start to say that this recommendation encourages agencies to present in a readily accessible manner in a readily accessible manner,
how
they appoint and oversee ALJs and AJs, and then by offering best practices to optimize their online presentation of these policies.
I think it makes sense.
Mm-hmm.
Need to be the heart of the recommendation.
Can you, if everyone likes that, can you repeat that a little bit slower for me? Are you suggesting taking out the first sentence and incorporating some of it into that? What's the second sentence we're currently working on?
I mean, it's yeah. So how about the first thing to do would be maybe to take that sentence starting with this recommendation lower down and make it the first sentence, the lower down one. Yeah, take that sentence.
Okay. So if I take this out, that makes this one the first sentence.
Yeah.
Okay. Yeah, but then I want you to, so this recommendation encourages agency to present in a readily accessible manner how they appoint and oversee ALJs and AJs, and then take off by offering best practices to optimize.
Do you want the rest of that original sentence?
Yeah, best practices for online presentation of the policies, of their policies. Of their relevant policies or applicable policies. Relevant or applicable policy, something like that.
And should it be encourages agencies to present how and offers? I mean, so it's the recommendation encourages agencies and offers best practices. I think it's an and, but
yeah.
Yeah, fine. By offering or and offers best practices to do so, just to simply for doing so.
For doing so online.
We have to make sure we really do offer best practices then.
Oh, of course we will.
Well, I mean, I think best practices goes not just to what, but it goes to how.
Any thoughts on this line as revised?
How about to present online in a readily accessible manner? At the beginning, where it says this recommendation encourages agencies to present online, comma, in a readily accessible manner, comma, and then take the online at the end. I don't like how online hangs there at the end of the sentence.
Yep.
Agreed.
I like it.
Good.
Okay, so that's now our lead sentence. Next set of lines, anything here?
Do you want to capitalize recommendation? Is there a reason for that in the old first sentence? Do we always capitalize recommendation?
I think as a general matter we do, Jack, when we're referring specifically to this recommendation or to a specific recommendation.
Oh, so you're saying here.
Yep. Anything further on the rest?
Russell, where we say consider providing on their website, recommendation identifies which kinds of information agencies should consider providing on their website and where and how they should do so. Does the recommendation on the next page really do that? It says where on the website as opposed to not on the website, but does it say much more than that? And just, I think it says prominently, straightforward on its website. But again, we don't want to get in the weeds of website construction, but do we want to emphasize more? Rather than say, as it says here, agencies clearly vary in terms of how they structure their websites. Well, yeah, that could be the problem, that they vary, and some make it prominently available and some vary it. And are we really taking on kind of avoiding the elephant in the room by saying, do it any way you want, but here's the way you ought to state it?
So just to flag this, I think bullet number 4 in the recommendations was intended to address that. I don't know if it's sufficient or if you have ideas on how to improve that, but that's where we were trying to locate that discussion at least.
My impression was that the sentence was accurate because, without going into a lot of details, there are some pretty specific recommendations about how prominent and where it should be linked, either on the front page if it's an adjudicatory agency or. So I thought that was an accurate description of the recommendation.
So is it more where and not how? I don't know. Maybe the how part is getting more into the tech piece.
I thought it was both because
okay.
I didn't think it was going, exaggerating. I mean, I don't think that anyone would expect the ACUS to be providing like a detailed, HTML code just to fill in or something like that.
I wasn't suggesting that, to be clear, but you got to be thinking about these sort of things. I mean, how many clicks does it take to get to the information, for example? You shouldn't have to. I think there is some evidence that after about 2 or 3 clicks, a lot of people just give up. And while we don't want to get into website clicks, we may want to say, give some indication that there is a body of information out here about how people can and cannot navigate websites.
Any specific language, Russell, that you think we should include or hear?
No, I wonder if when we see the redraft for the next meeting, some things may be a little clearer. Jack referred to paragraph 4, and my comment about that was need examples. I mean, I read that as a little too general to actually provide help to an agency who's trying to get a handle on what we're talking about.
We could put a comment in there to revisit at our next meeting. We may, I don't know how much time we have. I don't know if we'll get to paragraph 4 before we end today, but.
Can I ask a real quick question, Nadine?
Yes.
In terms of examples, if you look at it's Appendix B, I think in the report now, I did include maybe 4 screenshots from about 4 agencies. And maybe I'm not going into enough description in those, but one possibility, if you'd like examples, is for us to incorporate that as a second appendix for agencies so they can see some agency websites that we found particularly easy to navigate or that had particularly good descriptions of things.
You asked that of Nadine. I think that's an excellent idea.
I think we did that for another recommendation.
Yes, we did.
It's going to remember.
Yeah, I think it was the adjudication materials recommendation, if I remember correctly. Either that or adjudication rules, but there's definitely precedent for that we can integrate with the next meeting.
Okay. Great. Anything further on this part, this last few lines here? Great, okay. We have time, so let's dive into the first recommendation.
I don't think this one will fit all on my screen.
Yeah, I was just gonna say it's gonna straddle.
I can try.
No, it's fine. It'll be, yeah.
It'll be too small then?
Yeah, at least for me, I know. I don't know about anybody else. But.
You should be able to adjust the view on your own.
Could you insert a page break temporarily, and then we could get it more of it on the screen at once?
Can do that. There you go.
I mean, this will be sort of small, but there's all of one on one page.
And each person can change their own view in the lower right-hand corner with the zoom in and zoom out.
Oh, Roxanne, you're amazing. I had no idea.
I did that by accident and surprised myself.
This is great. Now I can really see it. There we go. Okay. All right. First recommendation there.
This Russell, short, straightforward, and prominently displayed, or easily, something like that. Maybe prominently displayed isn't the best word, but something to indicate it's not just the characteristics of the description, but how it appears on the website. Easy to find.
What if you just lead with, like, each agency, I can't see it now, sorry. Each adjudicative agency should prominently display a short, straightforward description.
Okay.
On its website.
Yep.
I don't know why I made that.
Yeah, it was unhappy there. Okay. Any thoughts on the list?
Item D, just to make the antecedent clear, especially duties that relate to investigation, those could be confusing. It could refer to adjudicators otherwise.
You know, it's a long list, so I'm giving people some time here to kind of think it through.
In 1A, this is Kent,
where
it says the procedures for assessing, selecting, and appointing. Is there a difference between assessing and selecting if we're talking about the pre-hiring phase as opposed to assessing somebody who's working there?
Okay, so I can tell you what I intended with this. I cannot tell you whether it conveys this, which is that assessing is more about what are the qualifications required. So when you're reading somebody's resume, how are you assessing their qualifications? And selecting is more about, I don't know if selecting and appointing are redundant, but selecting was what's the chain of authorities that looks this over and who is the final person that makes the decision and who looks at it earlier. And then appointing is sort of more the formal process of like, what are the requirements legally for appointing someone? I don't know if we need all of that or if that is unclear.
Any thoughts?
I would probably just say selecting. I can see the difference between selecting and appointing. I think assessing is within selection. That's what I would do.
Any objections to focusing on selection and appointment?
I think assessment is implied in selecting.
This is Judge Sullivan. I would disagree. I think that there needs to be a specific statement of assessment. It's a different process than selection itself.
Well, are there, I mean, the procedures, let's take a step back and think about what procedures an agency might have for this process. Would they have procedures that govern assessment, selection, and appointment? Judge Manuel, are you raising your hand?
Yes, I would agree with Judge Sullivan because there are factors such as whether someone's pre-qualified, what kinds of qualifications are necessary to even get them into the selection process. So there are certainly rules that apply to selecting, which are different than what things are fair to consider during the process of someone qualifying for the position. So I agree with Judge Sullivan. I think that assessment can be different, separate, apart from the process of selecting itself.
We have a recommendation, of course, on selecting and appointing ALJs. I'm wondering if that recommendation, the language there, is at all helpful with respect to what A should say here. I don't know the answer to that.
So we leave in assessing. I'm hearing two thoughts here, but I say we leave it in for now. We can always revisit. And I have a comment from William Funk, whose mic does not work. I'm sorry. I wish you could say this for yourself. So I will read what the comment is. In 1A, the agency should show not only the procedures, but also the authorities for. It is not clear that Section 2 covers this. So I don't remember what Section 2 says, so we can look at that.
Section 2 is about providing citations and links. It may just be that Section 2 is unclear and we should add that language to Section 2. We can also add it to 1A, but I think we'd want citations for many of these things, I would assume.
I think 2 stands on its own and informs 1. I don't think you have to move 2 into 1.
I'm wondering if there's a way to add language to 2 to make it clear that where appropriate or relevant, the authorities for the information. I mean, we say on the same web page as the information in 1, but should we reference to cover the concern that Mr. Funk has raised?
I think the language provide citations is meant to do that, but it currently reads like it's provide citations to key legal documents. And I think it's meant to say should provide citations for the authorities above, as well as links to key legal documents. That was the intent, and I think we're unclear.
Can we put a comment there so that we see about ways to build in some language as opposed to putting it in? I mean, I think as you're saying, there may be other beyond A that would benefit from the support. Okay, great. And I see Mr. Funk saying that would be good. Excellent. Thank you.
This is Judge McCarthy on the prior ACUS recommendation about selection and appointment of ALJs. The recommendation 3, it says agencies should develop policies to review and assess ALJ applications. So in my view, there's an assessment process that occurs before the selection process and then finally the appointment process. So I think in answer to Matt's question that the prior recommendation did draw a distinction. I think we should keep in the assessment as Judge Sullivan recommended. Thanks.
Thanks for looking back at that. That's helpful.
I agree. I'm sorry, it's Judge Manuel, but
yes.
Obviously, assessing and assessments is always a part of the selection process, but there are also certain aspects of it that can be.
Okay. Anything further on the list?
I had a point, this is Judge Manuel, a point of clarification on H, including the assignment of cases. It would be nice to have a sentence in there, or a word, I should say, indicating that the assignment process should be as random as possible or not based upon political considerations.
I was going to, go ahead.
No, please go ahead, Russell.
I said I was going to comment on that too, and whether or not, when I read that, I said, well, what's the link between supervision of adjudicators and assignment of cases? I mean, aren't those sufficiently separate that they could each bear their own entry? I mean, because as soon as you say including the assignment of cases, one immediately thinks of all the concerns that the speaker just raised.
I agree.
just keep in mind here that the project as approved specifically excludes any recommendations about what the content of any policy should be. It's very explicit in the description as approved by the council.
How about if you simply say, including the process of assignment, somehow allude to.
Well, couldn't you just have another entry? Supervision of adjudicators, a new I, this process for assignment of cases?
Sure, that's good. I like it.
I would actually just call it the procedure for assignment of cases.
That works.
Why was
The
just gonna-
procedure
I was just
for
gonna-
or of?
Okay, Roxanne, okay, she's muted. Go, Judge McCarthy. Judge, no, you're unmuted. You need to unmute. Thank you.
Thank you. Two comments. I mean, I don't have a problem with breaking up separate lines between supervision and assignment, although if we're talking outside the ALJ context, where the assignment is by rotation, I think assignment is inherent in supervision, much like assignment and direction of work is inherent in supervisor under the National Labor Relations Act. Second comment I would make is that I hope we're speaking generically here without getting into an individual system of records that arguably would be protected under the Privacy Act, which was referred to generically in the prior paragraph. So I don't think we're going to be naming specific judges' compensation and things like that, are we? I mean, we're talking generic in this list of policies and practices, right?
That's my understanding. I mean, so you're saying we can use compensation as an example. There's not going to be a line item with Judge McCarthy's compensation.
Right, or the evaluations of particular judges. I mean, I'm not sure, I'm not a privacy expert, but I just looked at 552AB, and there may not be an exception there that agencies can disclose this. But as long as it's generic, I don't have a problem with it. So maybe a privacy expert could again look at, is there any problem under the Privacy Act here?
Would it help if for the C we added the word structure? So we said compensation structure and performance incentives. So it makes it clear we're just talking about it generically and not for specific individuals.
I think that suggestion is helpful, yes.
I guess more broadly, can I ask the question of, we included the language policies and practices governing the appointment and oversight of ALJs and AJs. Is that insufficiently conveying that we mean only the not individual specific aspects of these? Is that a language concern that we should change?
I think it's fine, but if anybody else has concerns on that language. Judge McCarthy, did you have anything on that? The lead-in language.
Which specific language again?
Yeah.
I don't think I do have concerns about it. Could you just direct my attention to what specific language you're talking about again?
It's
the very
highlighted.
first sentence in 1 before the letter list. It says all policies and practices governing the appointment and oversight of ALJs and AJs, including as appropriate those that address, and then it's the list.
No, I don't have a problem with that because I think policies and practices, I mean, you're talking generically about what the agency's policies and practices are. I'm just concerned that you don't disclose records under the Privacy Act that pertain to individual adjudicators or ALJs at agencies where there's not an exception under the Privacy Act for agencies to disclose that. And I'm not an expert, so I just point that out for ACAS's consideration before they release the final recommendation.
We do have language in the preamble about that, but maybe the committee would like to consider moving some of that down into the recommendation.
I wonder if there's a way to use just some catch-all language, including, as appropriate and within.
We have as appropriate.
But reference like legal authority. I don't know, maybe I know that'll get struck. Never mind.
With the addition of generally applicable for policies and practices help?
I like that. Any thoughts, objections? Okay. Anything further on this list?
This is Kent. One small thing on E, it's the one about ex parte communications. I think I would put a comma after communications and say including between adjudicators and the other
Right.
agency officials, comma.
Right.
Mm-hmm.
Can't talk to the agencies, but you can talk to people outside. You don't want to imply that.
Exactly.
Judge?
Yeah, I have just a general question for the group. Whenever it's kind of a generic issue overall, whenever I see descriptions on the website by the various agencies describing their adjudicative offices, they almost always use the word independent. And they'll talk about fairness. Of course, that's the due process mandate, fair and impartial hearings. And I wonder if that is something that the group would recommend that we include in our recommendations for the various hearings under these recommendations.
Well, I think Kent did some previous work on that, didn't you, under another ACAS project, Matt? On the impartiality of the non-ALJ adjudicators, which is kind of a large subset of what we're talking about.
What are we talking about here? Making disclosures about matters that bear on impartiality, or are you talking about something more substantive and content-based to the effect that that adjudicators should be impartial, that the policy should require impartiality? Those are different things.
More like a preamble to sort of these recommendations. Should we mention that it's to the extent that I mean, in other words, the point was made earlier about the public. What is the public looking? What is the litigant looking for? What they're looking for is a judge who's going to be independent and adjudicate due process in impartial hearings. And the question is whether the disclosures here on the website should address that at all. And I just know that with most agencies, that's already done. They want to highlight that. They want the public to know that. And so do we have any suggestions that we could make in terms of language on agency websites?
Well, what do you have? Are you I mean, this recommendation is about disclosing policies that exist. Are you talking about creating a new policy here that agencies should then in turn disclose? Because that would be outside the scope of the project. Reeve, do you have any thoughts on this?
Yeah, I'm kind of struggling a bit with this as well. Like I think that's exactly right. That it would be beyond the scope to say something like, they should put, policies in place to protect impartiality and so forth. We're simply talking about to the extent that they have such things already, they should make them available on their website. So I think the way it's currently crafted captures that. But I don't know, Judge Manuel, if you have precise suggested language, but I think anything that goes to whether or not such policies should exist would be beyond the scope of the recommendation.
I'm wondering if the point of it, and maybe I'm not understanding, but maybe the point of it is that we're saying provide all this information on your website, but to the average person coming to look at it, are we going to recommend anything that says, here's why we're telling you all of this? So not that people are adopting new policies or anything, but just sort of providing even a small amount of context for why we have this list of information about our adjudicators. This example form that Kent has in the report, the heading says, how independent is the official presiding over your hearing, ? And then it lists all the information about the adjudicators. Is that what you're getting at, that we should just, it's giving context?
Yeah, to me, it's almost like the elephant in the room, but we're talking about the policies and practices that relate to these, that govern these ALJs and AJs. And really the whole point there is that they're providing, the agency is providing an independent adjudicator. And I don't know that to the extent that that could be said or is part of this project, I think it would be helpful to the public.
Just keep in mind the phrase, I mean, I think just one small response to that. Let's be very careful. I would recommend that the committee be careful about using the word independence. ACUS is usually pretty careful about that, and it's usually qualified with the word qualified independence or something like that. That will cause a big, that will cause a dispute at the assembly level if the word, if there's a sort of an affirmative unqualified statement that adjudicators are independent.
How about decisional independence?
I guess I would note the recommendation at this point also includes appeals from hearings, which in many cases might be conducted by agency heads. In that sense, you're not talking about the same kind of decisional independence. So while that may be applicable to hearing level, it may not be applicable to all adjudicators encompassed within this recommendation.
Good point.
I'm also wondering if this is an issue for the template that's currently included at the end, that for agencies for whom it does apply, we can include sample language, but since it doesn't necessarily apply to everyone, that would be the best place to leave it.
I think that's a good idea.
I forget how we changed the second sentence in the second paragraph of what we went through earlier. But it says the original draft said the public availability of these policies and practices promotes public confidence that administrative adjudicators are impartial decision makers. So I think we've addressed the concern already, but I think it does that what I just read, to the extent it hasn't been changed. Where are we now? Yeah. Judge, does that, I mean, haven't we addressed that concern already? Or haven't we said that's the purpose of public availability is to promote confidence in impartiality of the adjudicators?
Yeah, I guess it's just a matter of language and whether it's stated up front to provide context or as a part of paragraph 2. But yeah, I think that's the point that should be made.
I'm wondering if Leanne's suggestion of including that in the sample, I don't know, is it at the end? It's at the end, right? The appendix, I'm sorry. There is reference there to a neutral forum, impartial judges, whether there's some language that could be included there.
This is Jack. I think that the Matt, I wonder from Matt, would use of the word impartial or impartiality have the same objection as independence? Because I do think that it's more about that we're concerned about, because you know that adjudicators are fully subject to the policies of their agency. So they're not, independent in the sense of judges being independent.
No, I think I was just reacting to the use of the word independent, which is going to cause problems with some people. I think the concept of impartiality is fine and maybe perfectly appropriate. And I think, I don't know, Reeve or Jeremy, maybe you could speak further to this, but I thought that our recommendations on recusal rules referred to impartiality throughout. Again, that raises the questions about agency heads, apropos of Jeremy's point, and what exactly does it mean for an agency head to be impartial?
I mean, just to stick my nose into this, I think that impartiality is completely consistent with a commitment to a certain policy when the person who's committed to that policy is making policy for the agency. Just impartially applying it means you apply it without regard to persons. That is, you're not applying the policy because of who the person is in front of you. You're applying the policy because what you're doing is implicates the goals of the policy.
Yeah, no, I agree with you 100%, especially if impartiality is used in the way that you've just used it.
Well, that may be a way to couch the language then, but yeah, I think to have language that somehow encompasses the whole spirit and import of the APA could be helpful here.
Is that something that we can build into the appendix, or are you thinking it needs to be stated in the recommendation?
I think the appendix is fine.
Okay. We can look at that closer when we get to that, if that makes sense. How are we doing on time? 15 minutes, I think.
Can I just make a comment about the appendix? I mean, the appendix is limited to administrative law judges, and we're talking about a much wider variety of adjudicators here. So maybe you ought to have 2 appendixes. Maybe you ought to have 1 appendix that can cover everything. I mean, I don't know.
So I feel like I should speak to this because we drafted a second appendix for administrative judges generally, and it was so vague because of all of the variation across administrative judges that it felt potentially not useful. And so while I'm happy to either redraft that or include it, if it does in fact feel useful for the committee, I would say, having gone through that exercise, there may be a way to couch, because basically it copied and pasted a lot of the administrative law judge things and then just left things within that blank. And so I think it would be almost as easy for agencies with administrative judges to just use the ALJ template as the starting place, but we might want to clarify that or add a second one.
Well, I'd be interested in, and I hate to single you out, Kent, but I think you've written on the issue of impartiality in the AJ setting across a broad variety of adjudicators, and what your thoughts are on this concern.
Well, I guess I'm of kind of 2 minds. I see the issue with, as we said, we drafted the second appendix, and I had provided some comments too, saying essentially I think certain phrases that were used were a little narrow and they weren't accounting for the variety of administrative judges. So I can see some use in saying we've given you a template with administrative law judges that go through the key elements of independence that then speak to or seek to protect impartiality. And you can essentially just tell agencies to use this as their template for it. At the same time, I also would have supported having a separate appendix that used administrative law judges and just did keep it more open-ended. I mean, in fact, if you went back to the disclosure that I had used, that's essentially what I did. I just kind of had left the issue sitting there, and then it was for the agency literally to fill in the box of how they handled that particular matter. So I don't think it's that significant one way or the other, as long as you make it clear if you use just one that you're intending the one for ALJs to also be used for AJs.
I would just add that given the way the opening paragraph is currently drafted, which I realize might morph or change as we go into the next meeting, you know, at this point, we're talking about adjudicators in a broader sense than just ALJs and AJs.
Would it be helpful for the committee if for the next meeting I did copy in what we had for the template of administrative judges with the understanding that if everyone winds up thinking it is not useful, we can just delete it again, but so that everyone can see what we're talking about and have it on the table?
I think that could be helpful. Any thoughts?
This is Judge Sullivan. I think that would be very helpful. Thank you.
Judge Manuel? Did you?
I agree.
Okay, we'll do that. Where are we now? I think were we still on one? I realize we have about 10 minutes left, so I want to be sure if there was anything further on recommendation 1. Great. How long's 2? Can we tackle it in 10 minutes?
Yeah, I think it's pretty short.
This was where we talked about making it clear that the authorities and legal citations.
I have one suggestion. That is in line 2. Instead of saying citations and/or links, I would say should provide links. Let's take advantage of the website. Maybe you want to put in parentheses, you know, in citations if no link, if no URL is available. But let's tell them to put the links up so that use the website for what it's good for.
So maybe would it make sense to lead with links? Should provide links to legal documents and then kind of as a secondary or citations.
Yeah, I was trying to figure just how to do it in the sentence.
Should
provide links, parentheses, or if unavailable, citations, close parentheses, to key legal documents, so on and so forth.
Does that address the previous issue, though, about wanting to provide citations for the authority? Should I take the citations part out and then make a separate sentence about put citations in where applicable for authorities for the policies described above?
Go ahead, Russell.
I was just going to say, if there is a link to the actual document, the citation will be there. We're just talking about, you know, where to find it and what do they call those things, law libraries? I remember those.
You need both, Russell.
Provide.
This is Judge McCarthy. On the A, B, and C, I think it's pie in the sky. I don't think it's practical. I don't think agencies are going to go as broad as what's requested there and include links and citations to secondary sources. I mean, it's good to encourage that, I guess, as best practices, as a practical matter. I wouldn't do it as an agency head if you told me that. I mean, I think you gotta have the agencies provide citations and links to like their key guidance documents and stuff, but to make them go do research what OPM says on it or what, you know, the APA says on it, like, I don't see it happening. That's, call me a pessimist on that issue, but as a practical matter, I don't see that happening.
Is there any guidance set out in the Paul Ray OIRA memo about some of the information that should be made available. I don't have it in front of me. I just wondered if there was a tie-in there to some of that information that's considered a best practice.
This is Ken. Just one quick response to Judge McCarthy. I understand his concern about that the agencies may not want to go do additional research on what it is OPM may have in guidance, but is that something we could take care of in the template that we have in Appendix A, where it's already got the links to any of the OPM sources so agencies don't have to do the footwork?
Yeah, I think that would solve the problem. I don't know the answer, but I like that solution.
I don't know if we want to talk about this further now, but we have a bit of that already, at least for ALJs. I think my experience with trying to write it for the AJs is that mostly you're just cutting out stuff from this list of authorities, but we have the statutes and the CFR provisions that govern ALJs, and I can put in links as well.
I mean, hasn't ACUS already kind of done this? Instead of requiring the agencies to do it, can't we cite the work that ACUS has done already? I mean, way ahead of the agencies on a lot of this stuff, I would think, and it would be, I just don't see making the agencies recreate the wheel is going to work.
I don't think ACUS is in a position to work with every agency to supply links and so forth. Their agencies have at their disposal. Actually, I don't even know what I didn't even know that we have any links. I'm even trying to think of our adjudication database. I don't think it has links. I'm not sure.
Well, I think we'll end up revisiting paragraph 2. I don't think we're done with that one at our next meeting, and we are close, I think, to wrapping up here.
Nadine, may I just add one thing, if
Sure.
it's okay? Maybe before the next meeting, apropos of the first issue that we discussed about what the scope is, it might be useful for the committee members to review our other main adjudication disclosure recommendation, adjudication materials on agency websites, 2017-1, because that recommendation, in terms of its scope, is specifically tied to the type A, B, and C categories.
Could you send that out in an email, just so the exact document?
Yeah, I'm happy to include that in an email.
Great. Well, I feel like we've made good progress here. And hopefully we can wrap this up relatively quickly at our next meeting, which is, Gavin, I knew you were going to, it's November 6th, I believe, from 2 to 5. Did I get it right?
I believe that's
so.
correct.
1 second.
Right.
I had it somewhere here, but now yeah, 2 to 5, November 6th, which is a Friday. We'll have cocktails when we're done. I'm kidding. I think we can wrap up quite easily then. So I appreciate everybody's time today and great insight as usual. Any further comments?
No, thank you very much.
Thank you.
Right.
Can you send the edited draft around too before the next meeting, please? This is Renee. I rejoined. I apologize for being away so long.
Yeah, I should be able to do that.
That'd be great. You might have said that and I missed it. I apologize.
Great. Thanks, everyone. Much appreciated. Enjoy the rest of your afternoon. And we'll see you on the 6th.
Bye-bye.
Thank you, folks.
Thanks. Bye-bye.
Hi, everybody.